practitioner engagement with the subject matter that we're considering on a particular day. So, of course, while we consider every Ghanaian a stakeholder when it comes to constitutions and constitutional review, we believe that there are certain persons, by virtue of their expertise and experience, including working in organizations affected by or closely associated with the Constitution, bring exceptional insight into the work that has been tasked us, and therefore who can assist us, especially in trying to understand the sector, some of the issues from a perspective that may not be shared by the average Ghanaian, including some of us on the committee. So that's the idea of the stakeholder engagements. There will be a more open-ended public engagement at various locations across the country, including Accra, later on, where there would be no restriction as to the subject matter that one can bring to the table. But we have limited these conversations, initial conversations, to particular thematic areas of the Constitution. And so today's, like yesterday's, is on land and natural resources. And if you think there is a problem in that sector that the Constitution review must look at, or if you think the Constitution itself gives rise to a problem that needs a rethink, you are invited to share those perspectives with us. So thank you very much for coming, and Dr. Mantiao, the floor is yours. I think I skipped one important item, which is we must introduce ourselves. I'll start with myself on the committee, then my members who are here will also introduce themselves. I noticed today that we have contributed on this side to the gender imbalance. Looks like Constitution review is becoming an all-male thing. We are lucky to have a couple of women here who are breaking the pattern. But our membership is, we have 8 members, 3 of whom are women. They will join online for various reasons. They could not be here. They were all here yesterday. So my name is Kwesi Prempe, and I chair the committee.
Ibrahim Tanko is my name. I'm a member of the committee.
Rena Kumpergia, I'm the secretary to the committee.
I'm Godwin Jokuto, a member of the committee.
The other members are Justice Sophia Adinyura, retired Supreme Court Justice, Mrs. Charlotte Osei, a lawyer, and Dr. A.C. Ansa, an academic with Ashesi University. They will join us online, but I think one of them will be able to make it in due course. So thank you. Sorry, and Professor Kwame Kakari, who is not in the jurisdiction today. He's not in the country and may not be able to join us. So I think should we have maybe for the audience or the stakeholders who are here today, when it gets your turn to speak, then you can introduce yourselves. Thank
you. Okay. Thank you very much, Chair, for this opportunity. When we had the invitation, I thought we needed to broaden the conversation among the various interest groups in the subject. We incidentally have a coalition of CSOs that engage the various political parties on the natural resource sector in the lead up to the 2024 elections. And so there were a couple of issues that we wanted addressed by the various political parties, and we thought this was the opportunity, to the extent that some of them actually has to do with the constitutional rendition on certain aspects of natural resource governance. So the leading members of the coalition met, and we went through the constitution together and came up with a few areas for the consideration of this committee. One of the challenges in the fight against small-scale mining has been the complicity of traditional authority, or suspected complicity of traditional authority. The non-involvement also in terms of the combating of the menace. I currently work as the technical advisor to the UK Ghana Gold Program, which is a UK government support to the government of Ghana in dealing with the illegalities in the small-scale mining sector, illicit financial flows, and associated with it, the risk of financing of serious organized crime. So we've been in link with the communities. We work primarily in the Savannah area, Bole, Tinga, Daklupe, Dollar Power, and all that. And the constant complaint we hear from the chiefs is their non-involvement in the licensing process in terms of mineral rights. And they normally will sarcastically ask why they should be concerned, why they should be involved in the fight of against Galamsey when they are not involved in the allocation of the rights, even though they are the landowners and have the rights to the land. So we thought that we should find a way to involve the chiefs in the trusteeship that is currently bestowed on the President of the Republic. And in that sense, bring them on board and get them to support ongoing efforts at curbing illegal mining. Our position also aligns with the movement of change, which party in the lead up to the elections also made a pledge to amend the act to provide for the involvement of chiefs in the licensing process. In fact, their position was to make the chiefs co-trustees of the minerals. And so currently, I would like to continue by just reading what the current rendition is on this matter. It says, and that is Article 2576 of the 1992 Constitution, and it says, every mineral in its natural state in, under, upon any land in Ghana, rivers, streams, watercourses throughout Ghana, the exclusive economic zone, and any area covered by the territorial sea or continental shelf is the property of the Republic and shall be vested in the President on behalf and in trust for the people of Ghana. And this is what we propose to be amended. And the amendment we propose is this, to read, every mineral in its natural state, in, under, or upon any land in Ghana, rivers, streams, watercourses, throughout Ghana, the exclusive economic zone, and any area covered by the territorial sea or continental shelf is the property of the Republic of Ghana and shall be vested in, this is where the amendment is, in the President and traditional authorities of the area hosting the minerals on behalf and in trust for the people of Ghana. It continues that the co-trusteeship of traditional authorities shall be exercised through their chairmanship of the district mining committees or whatever nomenclature established under a decentralized licensing regime. So the co-trustees arrangements shall be for the purpose of involving traditional authorities in the decisions and management of the country's natural resources and does not assign ownership rights of the resource to the traditional authority. Rents and other benefits derived from the resources shall accrue largely to the state and spent through the national budget, just by way of clarification. Okay. The other issue we looked at was the membership of the Lands Commission. And there were two observations. First, we mentioned the Environmental Protection Council. That was the way the EPA was described then. Now it has evolved into Environmental Protection Agency and now Environmental Protection Authority. Given the trend of changes in the name of that establishment, we propose that in this review, we refer to the EPA as the agency of state responsible for environmental regulation. So no matter what nomenclature that we give to it, we will still know for sure that that is the regulator of the environment. The other observation we make has to do with the omission of the Office of the Administrator of Stool Lands from the composition of the Lands Commission. I want to believe that was inadvertent. So we propose that we take opportunity of this exercise to include the OSL as members of the Lands Commission. Our rationalization is actually rooted in Article 2678, which provides that the OSL and the Lands Commission shall, and I hear jointly, coordinate with all relevant public agencies and traditional authorities and stools in preparing a policy framework for managing stool lands. We therefore propose that OSL should be included in the membership to facilitate that collaboration. We also noted, and this, we are coming at this from the gender perspective, the omission of queen mothers in the composition of the Lands Commission. Again, this has come to attention through our work in the Savannah region, where queen mothers feel they are left out and dispossessed. In fact, they were laying claim to a share of the royalties that are returned to mining host communities. And the chiefs responded by saying, this is a house matter, they will deal with it. Because after all, the money they receive, they give it to the women to go to the market. So it ends up with them. But I think that we need to recognize them through this constitutional review process and make them members of the Lands Commission. And their representation can come. They are organized now. They have a Queen Mothers Association. And in the composition of the Public Interest and Accountability Committee, we were minded to get them to have a representation on that committee that advances gender interests in the discussions that we have on that committee. Then I move on to the Regional Lands Commission. This flows from the earlier thing because, again, the OSL and the Queen Mothers Association are omitted from the composition of the Regional Lands Commission. So we need to, if we address the earlier concern, then of course it flows from it. We need to address this other one, the Regional Lands Commission composition. Now I'll quickly move on to Article 2672, where we think there's a need for clarification of what constitutes stool lands revenue. I've been fighting raging battles with the OSL on this matter. You see, the Constitution is a bit vague and silent, I would say, on what constitutes stool land revenue. By reading the Constitution, the sense I get is that stool land revenue are those revenues that you derive in exercising, that is Article 2672. You see, stool land, to my understanding, refers to the revenues derived from the exercise of the surface rights to the land. Because the Constitution grants the landholder the surface rights, and the mineral right is granted the state. So things like, you see the mention of royalties in your revenue streams, the OSL revenue streams. In my thinking, that royalty refers to timber royalty. And you know, in practice, that was what you were doing before we added mineral royalty. So I think that all the revenues that the OSL manages are those revenues derived from the exercise of the surface rights. When it comes to mineral rights, the Constitution vested in the president. In fact, it's the property of the state. invested in the president, which makes it state revenue and not stool revenue. But that the Constitution does not make that distinction clearly. And so I know some chiefs went to court. Dr. Gad, I think you remember that instance. Some chiefs from the Bronga Hafo claiming that the entire revenue, the royalty, should be paid to them because of the name royalty and whatever. They made the argument, but they lost. But I think this is a time for us to address the matter in the Constitution, so we're all clear in our minds when we say stool land revenue, what it is, and state revenue, too, we are clear about what it is. So we are proposing a rendition that reads, stool land revenue shall refer to all revenues derived by the exercise of the surface rights to land, which is granted by this Constitution. All other revenues derived by the exercise of sovereign rights accorded the state in respect of minerals shall be classified as state revenues. In the case of mineral extraction, an exemption is made to cede 10% share of the mineral royalties ordinarily considered as state revenue to host communities through the Office of the Administrator of Stool Lands to address the harmful effects of mineral extraction and to support local economic development. When we do this, we'll be anchoring the MDF Act in the Constitution. If you look at the MDF Act in its current state, it provides a formula for the distribution of half of the revenues, which is to support the sustainability of the industry. The other half, which is to be distributed to the beneficiaries in the host communities, we don't have a formula for it in the MDF Act. You cannot have an act that does not clearly provide a formula. But I want to believe that the thinking was we could apply the constitutional provision in respect of the OSL. Let's provide clarity and distinguish between stool land revenue and state revenue, and then clearly state that what we are doing now by way of returning a share of mineral royalty to host communities is an exemption to the rule. And it is with the purpose of addressing the harmful effects of mining on the communities and to promote local economic development. I'll move on to the next. Article 2676. Still on that one. This has to do, the observation has to do with the disbursement of revenues accruing to stool lands. The current rendition requires that whatever accrues to stool land is for the purpose of what? Maintaining the stool in keeping with this status. Let me read the current rendition so we can all have a good appreciation of the problem. It says 6, 10% of the revenue accruing from stool lands shall be paid to the Office of the Administrator of Stool Lands to cover administrative expenses, and the remaining revenue shall be disbursed in the following proportions. A, 25% to the stool through the traditional authority. 25% to the stool through the traditional authority. For the maintenance of the stool in keeping with its status. Then B, 20% shall be distributed, 20% to the traditional authority, and then C, 55% to the district assembly. Now, the reference to traditional authority up there in A, and then again to the same traditional authority in B, creates some confusion. So we were minded to look at the Chieftaincy Act, and we realized that in the Chieftaincy Act there's a recognition of a certain traditional council, which is not recognized in this current provision. So we thought we needed to bring better clarity by requiring that the initial 25% is allocated to the stool, the other 20% is allocated to the traditional council, and then the rest to the assembly, which is 55%. And that actually reflects the practice. If I'm wrong, tell me. It reflects the practice. In practice, the traditional council receives the 20%, and then the stool receives the 25%. it is the two together, the stool and the transitional council, that constitutes traditional authority. But the way we frame it in the Constitution, we don't get that meaning. And so even by reading, you think the traditional authority is another body sitting somewhere. But in fact, it refers to these two institutions. And then there is a second concern, I think. Let me move on. There's a second concern in terms of what is meant by saying for the maintenance of the stool in keeping with its status. In my work as the co-chair of the Ghana Extractive Industry Transparency Initiative, we've actually had a lot of agitations around this. Community people feel that when you say the stool, it is not the fiscal stool, it's the institution. And that the chieftaincy institution represents the entire ethnic group. And therefore, the chief, who is the head of that ethnic group, should be accountable to the that community. But the Constitution does not provide for that accountability. So a lot of the times, what is allocated to the chiefs gets squandered or abused. But we are prompted that this was a delicate issue, and that even in the consultative process leading to the 1992 Constitution, it came up, and this was a compromised type of agreement to leave it at this. So we thought, okay, what we would need to do is to not to say maintenance of the stool, but expenses related to the maintenance of the, I was going for the chieftaincy institution, but I was cautioned that it could be too broad. So it's less limited to expenses related to the maintenance of the stool. Again, let's move on. Yeah, and then there's another component. We realize that we've always assumed, we've always assumed that the share that goes to the district assemblies were meant for development. And so the OSL is even in the process of fashioning out guidelines for the use of those monies. We just realized that the Constitution does not mandate that the assemblies use it for development. So we want to take advantage of this to require that what is assigned the assemblies, the local authorities, are used for financing local economic development. Let me quickly move on to Natural Resource Commission. What was the concern here? Yeah, it has to do with the list of commissions. At the time, we didn't have Petroleum Commission, so we didn't mention Petroleum Commission. Also, Water Resources Commission. We want to take advantage of this review process to mention them explicitly. Water Resources Commission and Petroleum Commission as those natural resource commissions that the Constitution mandates to be established. And then we'll have the omnibus provision and any other. Good. Is that all? Yeah, exactly. Again, in this country, we realized that major decisions around the governance of our natural resources are often subjected to the interplay of politics in this country. And in that process, the bigger national interests get lost. So when we discovered oil, incidentally, I happened to have been invited to chair the governance session of the then first Oil for Development Conference organized by then President Kufuor. And we made the point that we need to create opportunity for citizens' participation in the governance of our natural resources. But this is not enshrined in the Constitution. But we went out of our way to create the Public Interest and Accountability Committee exclusively for the petroleum sector. And we all can attest to the yeoman's job they've done and how they've contributed to transparency and accountability in the management of our petroleum revenues. We think we should ground this in the Constitution. And so we provided a rendition that says, there shall be established for the purposes of the governance of the country's natural resources, an additional citizens-led public oversight body comprising 11 members, drawn from A, independent policy research think tanks nominated by the think tanks fraternity, civil society organizations and community-based organizations nominated by civil society, Trade Union Congress, D, National House of Chiefs, Association of Queen Mothers, Association of Ghana Industries and Chamber of Commerce, Ghana Association, Journalists Association, then Ghana Bar Association, the Institute of Chartered Accountants, Ghana Extractive Industries Transparency Initiative, Christian groups, namely the National Catholic Secretariat, the Christian Council, and the Ghana Pentecostal Council on a rotational basis, the Federation of Muslim Councils and the Ahmadiyya Mission on a rotational basis, and then Ghana Academy of Arts and Sciences. This is the composition of the Public Interest and Accountability Committee, and we think we should take advantage of this process to give it grounding in the Constitution and to expand its mandate to cover all natural resources. Because if we require transparency and accountability in oil, I guess it goes to reason that we also require same for mining and other extractives. Thank you very much, Chair.
Thank you, Dr. Matiao. On the spot, 10:30. So we have devoted at least thank you very much for those remarks. We have devoted an hour for discussion, both from the committee. Committee will ask a few questions, and then the audience will also give their reaction, and then you can elaborate or explain or help us with some answers. So I'll invite my colleagues who want to follow up on this.
Thank you very much, Dr. Steve Mantiao. Just a couple of questions for clarity from your end. You spoke about the co-trusteeship between the president and the chiefs. I'm just wondering, what do you have in mind when you say chiefs? Is it the paramount chief, or is it the local chief where the mineral resource is found? That's my first question to you. Yeah. Because we need clarity on this.
Initially, yes, that's what we think, that it should be there's two. Maybe you can pick up a number.
So you can just pick up the questions and then you answer them when you have the opportunity to do so. So that's the first question. And I'm also thinking that considering the number of chieftaincy disputes we have, many of which are yet to be resolved, would it be a very good idea to now saddle the chiefs with co-trusteeship when it will be difficult to determine who is a chief at a particular point in time, instead of just allowing the president to be as the current arrangement stands? The other question I want to find out from you is, do you think we should continue with many natural resource commissions, as you have suggested that we should do water resource commission, petroleum commission? We should expressly mention them in the Constitution. Yesterday we had a suggestion that why we have a natural resource commission with subdivisions instead of having small units of such natural resource commissions. But we have one natural resource commission whose mandate is to deal with the full spectrum of natural resources. But the place should be filled with brilliant manpower, with expertise with the various natural resources. Then I want to find out from you in relation to the OSL, whether you think we should add them to the Lands Commission as a unit or as a division of the Lands Commission. Yep, I think this for now will be my questions. Thank you.
Thank you very much, Steve. Following up on the issue of the co-trusteeship, in addition to what Dr. Jokoto has said, yesterday there was a suggestion to move from vesting in the president to, I think, vesting in the state, am I right? Or the republic. Do you think such a suggestion would cure the issue that you want to address through this issue of the co-trusteeship? And then how do you think we can resolve possible, I don't want to use the word rivalries, but when you have two different, bodies, co-chairing, who is preeminent, whose word has a stronger distance comes up. We have a saying that a goat that belongs to more than one person usually sleeps outside because, you think one person thinks that the other is taking care. My second point is this distinction that you were drawing between the stool and then the traditional authority. Isn't it possible that in some jurisdictions there's actually a distinction, that the stool may actually be the paramount chief of the area, and the traditional authority is broader, includes all the sub-chiefs, the areas, and this thing. And therefore, just seeing that we should merge them might actually be overlooking this distinction, jurisdictions. Thank you.
Thank you, Chair. Thanks for your presentation. Now, I want to raise the issue of the relative benefits that accrue as between the host state and international extractive companies. I think that historically there has been an imbalance as to what accrues to host states, and this is well known. What would be your recommendations? First of all, do you agree that Ghana, as an extractive mineral host, benefits equitably, or if you like, substantially, from the resources that it owes? What would be the formula for distribution going forward? That's the first issue. Your first point about the complaint from chiefs that they are not consulted or part of mineral formulating contracts. I know that in terms of small-scale mining licenses, where groups of community people or small-scale miners group to obtain a license, there's a consultative process that goes on at the local level, including the district assembly. Would you not say that there's space for the chiefs and the local authorities to act at that level rather than isolating them and giving them a special treatment? Thank you.
All right, and then I get to ask my question. So on this issue of the Galamsey issue and your proposal to remedy it by bringing the chiefs into a co-trusteeship arrangement with the state represented by the president, I think it's an interesting one. First, my own issue is with the original formulation we have now, which is that this vesting in the president as opposed to vesting in the republic, and given the political culture we have here, where once you name and you allocate or assign something to the president, then it gives it a very personal kind of status. And then, of course, in the Constitution, we have also not proceeded to elaborate any responsibilities arising out of this fiduciary status, right? So even though we understand a trustee to be a fiduciary, the Constitution elaborates no obligations that the trustee, the president as trustee, owes to us as a country, whether it's by way of reporting, whether it's in the way in which whether it's about contract transparency, there's nothing. right? We only know that the president has the use of these various natural resource commissions that supposedly help the president in the discharge of his or her trustee obligations, but the Constitution imposes no such obligation. And as I understand, the courts have also essentially said, well, it's not something that we can enforce. So, one, would this not be a good opportunity for us to elaborate an accountability mechanism that fleshes out the nature of this trusteeship obligation, whether by way of reporting to Parliament or access to contracts or any mechanisms that you think will help us. And then secondly, then to the co-trusteeship idea. I mean, again, you know, my committee members have raised some of the possible challenges or problems with this formulation. Already we have a problem with holding chiefs and traditional authority accountable, right? So quite apart from the president, holding the president accountable is its own big issue. And now we are going to double that up with another institution that traditionally and historically has escaped serious accountability to the people, right? So you have two co-trustees for whom we have not a very good history of accountability and how that will work. If, I mean, the principle of getting local concurrence, consent, involvement in the issuance of mining concessions or licenses, I think the principle is certainly seems reasonable and just, especially if we want to change the incentives for local communities to be part and parcel of policing the mining and making sure we don't get the galamsey issues we're getting. But aren't there different ways of doing it other than this co-trusteeship arrangement, where you could have, you know, whether it's the president or whoever it is that's doing the allocation, seek the prior consent, concurrence, consultation. I mean, any of these other formulations of the traditional authority of the local community in some form before a license is issued. And can't we find some other less conflict-prone mechanism to do this than this co-trusteeship arrangement? So one is just the trustee arrangement itself, and who must we vest it in? Should we vest it in the Republic, as is done in many other countries? You know, Botswana, mining laws vest the mineral resources in the Republic. That's a common formulation in other places. It doesn't have to be in the president. And then if it's going, whoever it is that is going to be the one in whom it's vested, what are the implications? What are the duties that are owed by the trustee? And then thirdly, what other formulations could we bring in the traditional authority other than in a co-trusteeship arrangement? I think another issue that came up from some of our conversations yesterday, when you look at the chapter on lands and natural resources, it is almost, it's very heavily weighed on the side of the Lands Commission. We mentioned a number of natural resource commissions, but somehow only the Lands Commission, its composition and its role are elaborated in the Constitution, and then the others are left to statute. Are you comfortable with the current nature of the, you mentioned the composition, you know, we can put stew lands there, but that's not, for me, that's not. The current structure of the Lands Commission, is it fit for purpose? When you read the language, it appears to be an independent constitutional body. It has the same language, the same formulation that we have in some of the other independent constitutional bodies, which is that it will not take subject to the control of any other body or something, right? So you have that language, Article 265, except as provided in this Constitution or in any other law which is not inconsistent, the Lands Commission shall not be subject to the direction or control of any person or authority in the performance of its functions. Yes. Sounds like Shraj, sounds like an NCC.
There is an earlier paragraph, I can remember it.
Right, I mean, about the instruction on
directive from the minister
on policy,
exactly,
on policy,
exactly.
But not sure. So, but we know, right? I mean, what we know is that decisions around around these things are not limited to policy decisions, and that so how do we, fix this problem of the Lands Commission, notwithstanding this provision, right? This is proving not, in my view, not quite effectual. I mean, maybe the Lands Commission former boss will tell us if it is effective, but I think that the general view is that the Lands Commission is not, as contemplated here, independent when it comes to case-by-case instructions and transactions and stuff like that. It's not limited to just policy. How do we make this tighter so that the Lands Commission would play its role with a little bit of detachment from the political class and from micromanagement by politicians and others when it comes to management of public lands?
I'll take it from the trusteeship and make the point that ordinarily there shouldn't be any problem with making the president the trustee, because in the same constitution there is a check provided that all natural resource contracts shall be ratified by the parliament. So that offers a certain check. And to the extent that parliament represents the people, then of course that gives the people a certain say in the allocation of licenses. If we'll assume that members of parliament would have consulted with their constituencies before deciding whether to approve a certain contract or not. And so, for me, I think there wouldn't have been a problem. But the reason it's become a problem is this unending battle against illegal mining and our inability to win this battle. And the recognition that the chieftaincy can help us, the institution can help us. Let me cite an example where Otumfuo, working with the NIB, investigated some chiefs. And based on the evidence adduced, distooled 3 chiefs. That in itself tells us that, look, we can work with the chiefs and be able to stem the illegal mining because they are revered in the areas where they preside over. And yet they are not involved in our efforts to control the menace. So it is in recognition of what role they can play that we thought perhaps making them co-trusteeship, which provides another layer of a check on the president's trusteeship, could be the way to go. And in guiding the discussions, I cited the committee that I chair, which is the Ghana Extractive Industry Transparency Initiative. There are 3 constituent, groups in the steering committee. The companies, and the companies have representation from the Minerals Commission, Chamber of Mines, and then an alternate from industry, a producing company. Then we have all the government agencies that operate in the mining sector, and then we have CSOs. And then the chief director of the Ministry of Finance becomes the co-chair to the CSO's rep. CSOs, we have only 3 slots. So you find that government agencies dominate the committee. But in decision making, the rule is that we should achieve consensus. So if one constituency upholds consent, we don't make progress on any issue until consent is achieved. And then that forces us then to make compromises. And so people begin to shift positions until we get to a ground which is acceptable to all the various constituencies before we make progress. And this is how we have operated for 20 years without problem. So we realize that sometimes arrangements of this nature move people to a certain compromise position that will reflect the best interests of the state. We also took notice of the fact that the UN actually also is pushing for the free, prior, informed consent of indigenous people. Of course, in Ghana, we don't have that problem, but we would consider the inhabitants of a particular local area as the indigents. And so if you are taking their land for mining, then you need their free, prior, informed consent. But we do not, as a country, have an established framework to implement that UN requirement. So we thought, could we then maybe that free, prior, informed consent, exercise it through the chieftaincy institutions, being a co-trustee to the president, so that before a decision is granted to mine, he must assent to it. If there is a disagreement, then of course they will have to negotiate and come to a certain common ground before we can make progress, as we've worked on.
Do you think there's going to be disagreement? I mean, just being practical about it, right? Not being theoretical. The chief and the president are sitting in the room as co-trustees, right? I suspect that room is not accessible to the media, to the public. How they do their co-trusteeship thing, like with the president and the Council of State, we don't know. It's going to be a black box. Nobody knows what goes in there. And they come out smiling. Oh, we have approved the license. That is actually how it's going to happen. Is that not? Right? I mean, looking at the ways in which these kinds of things work in practice, this is how we have to approach it, right? Look at it, the worst case scenario. I mean, if you make a constitution thinking that the people involved are going to be angels, you get some of the kinds of very permissive rules we have made in our constitution. But if you think realistically that humans are going to be humans and they are going to be self-interested and they are going to do things the same way, which is how I think we should approach this. Is that the formulation you would have? Co-trusteeship between the chief and the president?
Yes, Chair. I think your position is a bit speculative. I'll give you...
But yours is too.
Yeah, I'll give you concrete evidence, anecdotal evidence of what happened with respect to the Achim mine. The Achim mine, Newmont's Achim mine, delayed for 7 years because the people of the area did not agree to the use of a huge crater that will be created as part of the mineral extraction. And so the process was delayed until a certain accommodation was reached with the people of the area before the license was ratified. So it has happened in real life that. Yes. So the people of the area are usually represented by the chiefs. And usually the agitation to reject a project starts with the people and the chiefs lead. I'm pretty sure OSL will tell us when the chiefs wear their kuntum and match their officers, it gives a certain message to them to act with dispatch. So there is no detachment between the people and their chiefs. And we all know we come from traditional areas and we know how we revere our chiefs. So the positions taken, I don't see how Asantini takes a position and the rest of Asante will take a different position. As the chiefs will usually act on the basis of the agitation from the ground. And there have been instances where chiefs have been stood for going against the wishes of their people. So there are these checks that we can look at. Of course, I'm open to superior arguments on this matter. But I think that there have been instances where projects have been delayed or rejected because the people, through their chiefs, actually rejected it. Yeah, so I continued. So I move on to chiefs. Okay, right. There was a question asked, the distinction between chiefs and paramount chiefs. I mean, there's two, the distinction. Yes, in most of the areas, the only exception is the Ashanti region, where Otumfuo owns all the land. But in the area where I come from, the chiefs actually own, most of the lands are even held by the chiefs, the families and the chiefs. So there is a case to be made for all jurisdictions except the Ashanti region, where the paramountcy controls all the land. And so I'm not too sure that this came up in our deliberations, but we could not find an answer to that. So we left it at this. We'll welcome other views on it. But chiefs, exactly. Exactly. And I think in practice, OSL, correct me if I'm wrong, your allocation of a share of the mineral royalty goes to the occupant of the stool of the area where the mining takes place. Exactly. So this reflects the practice as well.
So about the question on disputes, chieftaincy disputes.
Yes, we've had them, and we still have them. I know when you look at Otepolu area, the limestone mining, we are not paying money to anybody because of chieftaincy dispute. And the monies are being held in escrow account at the Bank of Ghana until they resolve the matter. So where there are disputes, we can follow that convention of keeping the money aside and resolving the matter.
The issue is that in the other case, it has to do with the revenue. But here, they are the co-trustees themselves to take the decision. So the two are not the same.
Well, I'm open to other views on this matter, but I think it's something worth considering, how you resolve this matter in the event of any dispute. So I wouldn't comment further on that. I'll leave it to people with superior views on that. Then there was the issue about whether we should not create a natural resource commission for all our natural resources. It makes sense to me, and I think I see a certain traction towards that. As we speak, government is working towards the creation of a common act to cover the entire natural resource sector, so that we harmonize the fiscal terms and all the governance principles in one document, so that no matter where you go, the reference to the law will be one and not the several laws that cover all the various natural resources that we have in this country. So I buy into that. And I see a certain traction in terms of the legislation making in that front. And so we can give it an anchor in the constitutional process. OSL, making OSL part of the Lands Commission. In fact, I don't even see why we separated them, because they are all about land administration. And I think even in the registration of our lands, we go through the regional OSL, isn't it? When I was registering my land, my first point was to go through the OSL first, and then I moved on. I don't know what the current situation is, because we've gone through various layers of land administration reforms. So I don't know what the current position is. I haven't bought land lately. But I think that it makes sense to make the OSL part of the Lands Commission, and they will be the stool land division, whilst maybe another division manages the public lands. So you have one body.
I think the proposal yesterday was to expand the scope of their remits to include public. I thought that the proposal yesterday was that once you merge them into the commission, then you could actually have them deal with all revenues, as opposed to just two lands revenues. But that's just one. That was just one proposal.
Yeah, but you see, the only revenue that is distributed by OSL is the one that is derived from their mandate, which is the stool lands. All other revenues will have a common framework, which is governed by the Public Financial Management Act and the budget. So I don't think there's a problem on that side in terms of revenues derived from state lands or vested lands. So I wouldn't bother too much on that. I think the only problem has to do with stool lands and related to that small-scale mining, basically. Okay, then there's a suggestion to merge traditional. The suggestion was not to merge traditional council with the stool. No, they exist separately. But we see a certain inconsistency between the Chieftaincy Act and the Constitution. Traditional councils are not recognized in the Constitution. They are not mentioned at all. And yet, in practice, they receive a share of mineral revenue. And we think it's not right, because it opens that up to contest. So I said, let's amend the Constitution to reflect the practice to the extent that the practice has worked so well. So we have 10%, which is allocated to the Office of the Administrator of Stool Lands. The office takes 1% to cover its administrative expenditure. The remaining is converted into a whole. 55% is allocated to the assembly. And I say we should actually add that 55% should be applied to local economic development. Then 25% is allocated to the stool. And then 20% is allocated to the traditional council. That is the practice. But when you go to the constitution, it says you allocate 25% through a traditional authority. Now, what is that traditional authority? It creates the impression that there's a certain body sitting somewhere who is the traditional authority who will receive the 25% and pass it on to the stool. But in practice, you pay straight to the stool, isn't it? Who do you pay to? What is the traditional authority? No, the 20% goes to, I thought everything goes to the chief and then it's apportioned 25. Let's hear what the practice is, then that will inform the debate.
Thank you very much. What happens on the ground is that the 25% to the stool is paid through a traditional authority. And this traditional authority, most of the cases are the traditional councils. And then we give them, you write the check in the name of the stool, but passes it on through the registrar of that traditional council because they know the stools, and then they take those checks to them. Okay. So the registrar
and then the other 20% goes to who?
The other
goes to traditional authority.
Goes to traditional authority, but in that case, our law defines who a traditional authority is. When you look at the Administrator of Stool Lands Act at 481, it says that traditional authority means a house of chiefs or any council or body established or recognized as such under customary law. We take it as such. In some of the cases, in certain places, you don't even have a traditional council. We had Ahafo North Divisional Council, Ahafo South Divisional Council. So those monies are paid through that divisional council because it's an authority that is recognized. So
can we amend to say traditional or divisional council to reflect the practice and avoid ambiguity?
That is fine. Thank you.
Well, it's not. Well, I think it's still, Dr. Mantia still has the floor. Once he's done answering the questions that were posed to him, then we can take another round of questions, and then he will react, and then we will conclude that session with him.
So, Chair, the concern really is about the lack of consistency in terms of the recognition of the institutions. The Chieftaincy Act recognizes and references traditional council, and in the Constitution, there's no mention of traditional council, and yet they are recipients of benefits from mining. I think we need to.
Is this a source of dispute on the ground? I mean, has this given rise to problems in terms of our practice, understanding of 267, 267, is it B, right? I mean, is this mention of traditional authority as opposed to traditional council something that's giving rise to some dispute? Or
it has the potential.
Okay.
It has the potential. And I think that in lawmaking, we don't leave it open in this manner. There should be no ambiguity at all in terms of what is being referred to. And so we thought we should take advantage of this process to iron these things out so it becomes clear to everybody what the references are. Then I move on to benefit sharing between companies and government or the state, and whether it is fair. And I will precede my response with the fact that we as a people do not seem to attach any monetary value to the natural resource that belongs to us as a people. So we go into negotiations with a mindset that this thing has no value. So let's sit down, come and mine, and give me something. But if you attach a monetary value to the resource which belongs to you, then that monetary value becomes your equity in the transaction. The current arrangement we have is that the investor brings his capital, mines and pays royalty. And by the way, the royalty is mostly recoverable. So in actual fact, he's giving you nothing. He's just giving you money that he'll take back later. So you don't count that as a benefit. And then he pays corporate income tax and other levies. So what do you get for the value that you bring to the project, which is the mineral? Nothing. It is not considered as anything in the negotiation of the fiscal terms. If you want something, the best you can get currently in our Minerals and Mining Act is carried interest. That's the only thing we get. But the carried interest is actually tied to dividends. And we know sometimes through creative accounting, companies can operate for years without declaring dividends. And even when they make super profits, as they are making now, because of the increase in gold price to about $300 per ounce, they will now decide in the boardroom to plow back the profits into investments. And so they won't declare dividends. So the resources, and there is evidence, that through my committee, the Ghana Extractive Industry Transparency Initiative, there's evidence to suggest that a lot of the companies operate for about 15 years without paying any dividends to the state. And then after 15 years, they either will sell the mine and go away with all the profit they've made from this country. So I think time has come to do that. Take another look. I led my committee to do a paper for the previous government. And they asked me, and the position of the committee was that let's treat the carried interest the same way we treat it in the oil sector. And I know Theo is familiar with what I'm talking about, where it counts for a share of production. So if you have 10% carried interest, treat it as equity. So together with the paid interest, then you get a certain share of production. I don't see why we shouldn't treat our mineral revenues or the mineral contracts in the same manner and tie it to dividend. It doesn't make sense to me. Again, going forward on the question, what the state gets is a function of the state's contribution to the business. It's an equity relationship. So I keep telling, sometimes we attach so much sentimentalism to the discussions around these issues. But I think we should see it as a business. And if I had my way, having mined gold for over 100 years, this country should have had a vote from which it will take money, hire people to come and mine for the state and pay them and let them go away. Like Saudi Aramco. They do service contract. Come and provide the service, I'll pay you, and everything that you produce is mine. But we produced gold for over 100 years and became a highly indebted, poor country. Are we not ashamed of ourselves? Who mines gold and become poor? Because we treated our mineral revenue as income for consumption. Your golden share in the Anglo Gold Ashanti, you sold it and used it to pay salary. So if I ask anybody to show me what gold has done for this country, there's nothing we can point to. But if I ask you to tell me what oil has done for this country, you can point. At least, if nothing at all, you can point to Atuabo Gas Processing Facility. And for many of you who are not aware, Kotoka Terminal 3 had $30 million of oil revenue invested in there, and today that money has returned $10 million as returns on that investment. So your $30 million investment is now $40 million. Assuming if we were to invest the bulk of your money this way, you would have actually, you can even imagine how much returns you'd have generated, which then would have allowed you to use that money to hire people to come and mine for you. You pay them and they go away. And then you decide what to do with your mineral. Again, there's something that we did not recommend, but which I want to take advantage of the trend of the discussion to bring to bear. This country has huge deposits of iron. And we also have huge deposits of manganese. but we are actually extracting all the manganese and shipping them abroad. We have not started exploiting our iron ore. But when we start, we want to do an iron and steel industry. So we have set up an institution called GISDE, Ghana Integrated Iron and Steel Industry. For you to do your steel industry, you need manganese. And you are shipping your manganese out in its raw form. When you come to develop your iron ore, you need to import manganese to do it. It doesn't make sense. So time has come for us to think through. I think the discussion around natural resource government is much broader than sometimes than the Constitution actually envisages. And I would like to conclude quickly by saying that the role of chiefs in the licensing process currently does not make them feel part of the system. So you sat in Accra, and that's the way they put it. Somebody sits in Accra and awards a license in my jurisdiction without informing me, without consulting me. They go and put a notice at the assembly, and they expect me, Nana, to walk to assembly to go and read that notice. And things are going wrong, and you are blaming me, or you want to hold me responsible. I wasn't part of the decision. So I think that the broader issue is how do we make chiefs part of the decision making and therefore hold them responsible for their illegal activities that goes on right there in their jurisdictions. That for me is a question we need to address. Thank you.
Thank you very, very much for this round of Q&As. We will invite further questions, another round of questions for Dr. Mantiao. In the meantime, I wish to recognize the presence of the ladyship, Justice Sophia Kufu, former Chief Justice, current member of the Council of State. We are privileged to have her join us in this session. We read something in the media that she had said about the extractive industry, which is what compelled us to invite her. We already had her in our sights for a conversation around judiciary and others, but obviously her interests are much more extensive as her experiences, so we thought she could also share some insights on this very important subject. We thank you for making it to our meeting. Thank you.
Since the mic is so close to me.
You recognize yourself? Okay, please proceed. Introduce yourself and then...
Are you going to use my name, former Attorney General? Doctor, we have all been worried about this revenue from extractive industries. I was sent out as High Commissioner to Canada. We were giving instructions to look at foreign direct investment. We went there and spoke plenty. They won't mind us. Their interest is only in the extractive industries. They even have a Toronto exchange or something where they can give money, venture capital for people to come and try and see what they can get from us. But setting up industries here, it's out of the question. What difficulties have you faced in trying to get government to understand that we need to work on our revenue and get something, our mineral revenues, so that we can get something out of it? You keep talking about this. What have been your difficulties?
We'll take 3 or 4 questions this round. And then, so we'll just go in order. Just next.
Thank you very much, Dr. Steve, for your presentation. This is it's just for clarification. Oh, my name is Gad Asowe Akwensivie. I'm the acting administrator of Stool Lands. So as an office, we have continuously sought clarification and in fact continue to seek both judicial interpretations and sometimes administrative clarifications on issues that border on our work. And one of them is on whether mineral royalty, as you alluded to, constitutes stool land revenue. So in 2000, we sought advice from the AG, who explained that mineral royalty forms part of stool land revenue, and that is the reason why we mobilize and disburse that. And that is for judicial interpretation. Yes. Then again in 2019, it became an issue. The other one, which is, that was an administrative clarification. The other one, which also borders on what you talked about, has to do with whether or not compensation from compulsorily acquired land constitutes stool land revenue. We were of the opinion that if we take revenue from land as stool land revenue, then if the land is acquired by the state forever and compensation is paid, that money should be construed as stool land revenue. We tested it, we went to the Supreme Court, and in the case of Okofo Subinkan versus the Attorney General and the Office of the Administrator of Stool Lands, the Supreme Court held that compensation did not or does not constitute stool land revenue. So just to explain what you talked about on whether these constitutes part of stool land revenue. Thank you.
Thank you, Mr. Chairman. On the issue of the clarity on the, my name is Dixon Agboga. I'm a staff of OASL. On the issue on the clarity on the traditional authorities, as mentioned in the law to be traditional authority, which we say is traditional council, I think we need some clarity on that, because just last year, one stool in Accra here sued us. And they were claiming that they belong to a traditional council that we pay money through. But they were saying that the law does not specifically say traditional council. So they want the money to be paid to them through a divisional council. It was just a way of avoiding part of the money going to the traditional council they belong to. So I think if we give clarity to that, it will be very helpful. The other thing I would like to bring to your attention is this issue of some of the people claiming not to be part of any of the traditional councils at all. It's sometimes worrying. So if we can give it a clarity, I think it will be helpful. Thank you.
Chairman, can I ask a question? Okay. Hi, my name is Agatha Roxon. I'm an academia and a lawyer as well. So thank you very much, Dr. Steve. I mean, I've gone through a few of your areas that you've proposed, but there was one that I think was lacking in terms of, we've all been talking about stool lands, but I know some of the southern lands, families, so like the eastern part of Ghana, there is the family, the Ekriapims and all that, is the families that owns the land. And also we have, in Accra, we have some of the private lands as well. But Eastern, I know they are mining there as well nowadays. So in terms of that, with the allocation in the Constitution, have we taken care of that? Because there will be, I know for a fact, a friend of mine called me in terms of a legal issue. His farmland is being targeted by Galamsey people in Eastern region. And so there should be something that can be catered for in the Constitution, not just two lands, because in Ghana we are so divided in terms of culture and how we acquire lands here as well. Thank you.
Thank you, Chairman. My name is Noah Adamte. I'm the research lead for the Constitution Review Committee. Doc, you were addressing an issue on the language on the distribution of stool land revenue. And I think you touched on the statement concerning the use of the revenue to maintain the stool. But it seems the proposition you made, at least according to me, suggests adding only expenses relating to the maintenance of the stool. And in my mind, I don't see the major change that would introduce. I felt some hesitation in your voice concerning that. And even you mentioned that it's your knowledge on the field suggests that it's about a compromise. Looking at the figures that the OSL mentioned yesterday concerning how much they gather as revenue, they mobilize as revenue, do you think that 10% of that going to the maintenance of a stool as against the development that may go on within the catchment of that stool? Do you think that the language should take into account that aside the percentage that goes to the local government, whether that should also be catered for in the amount that goes to managing the expenses of the stool? So that if a stool is taking 10%, around 5 million Ghana cedis, let's assume, that's huge amount alone does not go to the stool and then a few elders helping the stool in paying expenses relating to that. Then it could be broadly shared across the community. What do you think about that?
Chair, there's a small clarification I want to throw on this division and traditional council thing, especially with Greater Accra. For a very long time, we only had one GA traditional council with one paramount chief. The rest were all divisional chiefs. And they collect their monies and tell them the thing is meant for a traditional council. So they go and pay to the GA traditional council, and the money is meant for, say, Usula, Ateshin, whatever. So they were complaining. And I remember Nungwa people coming to me with a vehicle on which they've written Nungwa traditional council. I say, how? When did you become a traditional council? You are only a division. Go and change what you have written and write division. And then they explained to me that they are losing their money. Their revenues are being paid to the traditional council. And whatever they say, OSL or what, will never listen to them. That the law says traditional council. Now there is some respite because Osula Teshinungwatema are non-paramounts with their own traditional councils. So that was a real problem in Accra for some time. Thank you.
So here you are, Chair.
Mr. Chairman, just one more to support what Dr. Mantial said about the use of the stool and revenue. Actually, if you look at Regulation 21 of LI 2377, OSL LI, which we gave the committee yesterday, the LI mandates, or the LI specifies that the assembly should use their portion of the money for development. If we can look at that and craft it into the constitution, it will be helpful. And also the use of the stools portion of the revenue.
So you use the regulation processes to amend the constitution.
It's expatiation.
That is wrong.
Expatiation.
No. Because the constitution was silent. It says give 55% to them. So you cannot use the regulation to amend the constitution by adding that.
No, I think the point he's making is that the problem you are trying to cure is cured in the LI, so we should borrow the language and insert it here, and it takes care of the problem.
Oh, I'm just raising this as a caution because a lot of the times we use the regulatory processes to really amend laws and constitution. So you find that there's a certain regulation. You go back to the primary law and you find that the primary law does not mention it. So how would you, because look, in lawmaking, you say what ought to be, and the regulation will show you the how. So you don't go treating regulation as if you are making new legislation. It actually happens a lot in the mining sector. And so let's make sure that when we are developing regulations, we refer to the primary law or the constitution and make sure that we don't add anything additional. We only demonstrate how the thing will happen and not say this should happen in addition.
Mr. Chairman, a small contribution. Yesterday we did indicate that we don't want the constitution to be voluminous. Now, this issue of 25% to the stool in keeping with its status, what does it mean? So you could have a situation where a law could explain. In fact, when you go to at 123 in 1962,
when you look at the stool land revenue, what is supposed to be used for by the stools, it mentions the maintenance of the stool or other traditional authority, including a traditional council, and B, in the making of grants for projects, including scholarships for the benefit of the people of the area. So it's like some of these things, we don't expatiate them in the various enactments. So it sort of gives a skewed or a smaller meaning to what we want to portray. So I believe that we've not stated some of these things, but the law could expand it. It's given to them for what? We could also expand upon it by giving some of these indications. Thank you.
Okay.
Okay, so we have an opportunity. We want to make your regulations and law consistent with the Constitution. So now I support the suggestion that we are clear in terms of what the use of the monies assigned the Assembly should be, sure. And that is for development. We proposed that already. Honorable Ayuko, to ask difficulties we were encountering. When it comes to resource investments, I think we haven't done too well as a people. And I think it reflects our general attitude as Ghanaians. We only think about the money that is coming. We don't think about the cost. I recall when Atlantic Lithium made their discovery, the U.S. Embassy arranged a visit a visit from the U.S., from Piedmont Lithium, which is the company, the biggest off-taker in this arrangement, taking about 50% of our lithium production. And the CEO was in town, and the U.S. Embassy arranged a meeting between myself and him. Apparently, they were doing some risk analysis. So I indicated to him in my conversation that the biggest risk to their project would be demands from the communities for jobs. And so if they can think about doing some minimum processing here to absorb some of the labor that cannot be directly absorbed in the mining activity, that will actually help mitigate some of the agitations they will be getting from the communities. Their response to me was that it is not their business model. That the US government has passed a legislation to go around the world, find critical minerals, conquer, and bring to the US to challenge the Chinese hegemony over critical minerals. So they were here in pursuit of a certain interest, their national interest. Now I ask myself, when we go to the negotiation table, what interest do we take? Chair, you will be surprised to learn that we are supposed to have representation on all the boards of the mining companies. We do have representation, but most of the time they are members of parliament. They attend board meetings, they don't bring any report. They don't get any briefings from the state in terms of what they should go and pursue in terms of the national interest at the board level. They just sit there and they get paid allowances and their children. On one occasion, in fact, the rep on Anglo Gold Ashanti was just touring the world while they were working in Ghana, and children being given scholarship by these companies to go abroad. So we haven't really, as a country, identified a common interest. I keep saying that, look, every country, when you discover the natural resource, the first thing you should do is to begin to negotiate with your people in terms of what your vision is for that mineral. And that vision should guide the development of the governance framework, your policy, your law, and your regulations. So if your vision is that we want an integrated iron and steel industry, you immediately stop the export of manganese in its raw form, because it is inconsistent with the national vision. But because there is no vision guiding the way we do things basa basa. And that is how come we've mined for these years and we are where we are. So I think first and foremost, we need to do a cost-benefit analysis. And we've pushed this several years with various governments, but no government seems willing to do it. But we need a cost. We keep reporting what we get by way of revenue from our mineral extraction. But we have never reported. I know the balance sheet consists of cost and what? Profit and loss. Okay? So what is the cost to us? What is the loss? Our environmental cover and all that. We lose all this. We destroy our cultural heritage to give way to mining and all that. These are things we need to quantify. I recall I was invited by Newmont to go and review a report they had done on their socioeconomic footprint in Ghana. And in the report, they indicated they had created some 48,000 jobs since they've been in Ghana. 48,000 jobs. The impression is that their impact is so phenomenal. Then I took the podium and I asked them, how many jobs did you have to destroy in order to create the 48,000 jobs? Because the people were not ideal. If you displace one farmer, you've displaced a market woman, a choba operator, the akantie, the hunter, and all that. So once you take that land on which they were earning a livelihood, you've displaced many people along the value chain. You need to compute all that, offset that against the new jobs you've created, and let's talk about net job creation. So we don't do the cost side, we always do just the benefit side, and we don't get the right picture as to whether it's worth continuing mining on these fiscal terms that we mine. This is a question we need to address. A broader question for discussion. I think in the interest of time,
we are looking for answers, not questions. Right? So for the benefit of the committee, in terms of you laid out some alternative vision in terms of fiscal regime. If you could put that in writing and help us with what it is that you have in mind, and if you think that some other jurisdiction, peer countries, Africa, anywhere has gotten it right, that we could take a look at, right? We hear about Botswana.
Incidentally, I've been there.
Actually getting some very good deals from their minerals recently, including in their negotiations with DBS. Is there something there that we could emulate for purposes of this exercise that we could put in a constitution, not just in legislation, but in the constitution? If you are aware of some of those comparative models that you think make more sense and would work in our system, we would be very glad to have those as well.
Thank you.
So, Dr. Steve Mantel, and I think Tio could also help. The Constitution was crafted before we discovered hydrocarbons, petroleum, and we have a legislation that deals with it. Do you think that there are some provisions in the Petroleum Act that we could elevate to constitutional status to help deal with the natural resource governance in this country?
I'd rather go for some general principles around the broader natural resource governance that should guide the development of legislations. That one you cut across all the sectors.
Okay. So, let's give the mic to Mr. Theo Ehring, and then I don't know if Alaji, you want to also react to some of the points around the Lands Commission later on.
No, I thank you. This is Theo Ehring. I've been introduced. I think general principles at the level of the Constitution would be helpful. But I also want to buttress the point that Dr. Steve Mantiao made, that the real value in natural resources, especially in the case of oil and gas, is derived when there is a more holistic view of what you're looking for. More often than not, we look at revenues that are coming in the form of the conventional fiscal terms, which is royalty, income tax, additional entitlement, carried interest, etc. But I think if you look around the world, the real value has come out of how you leverage the resource into utilization. And I'll cite a few examples around the world. I mean, you look at something like, for example, the utilization of natural gas from Nigeria in Ghana by the building of the West African gas pipeline and bringing the gas into Ghana. If you try to monetize the gas itself, the value might not be much. But if you look at the broader value of bringing gas that otherwise would have been flared in that region, pipe it across a number of countries, come and replace otherwise maybe crude oil that would have been much more expensive, and a job that it creates. So the value is usually much more, several-fold, than the revenue that we collect. So it's not more of a, I wouldn't say it's more of an issue of constitution, at the level of constitution, but it's the philosophy around how we want to leverage a natural resource. And Doug did mention that it's something we really need to look at. Else, before you realize, you just pick few elements and you lost the greater value. Thank you.
Okay, I think it's on our itinerary for today. I think it's time to take a break, and then we will be back here at noon for our next presentation. I have here Nana SKB Asante. I don't. He's not coming here in person, so maybe during the break, let's make sure that he's aware that he's next and that he's already signed on online. We've sent him the link for his participation. So we'll take a short break and reconvene at 12 o'clock. Well, that's plenty of time. It's a coffee break. Well, okay. It's about 24 minutes of break. That's plenty. But there's coffee outside, and we'll be back here at noon. Thank you. With somebody who gives us a very good overview of the sector and who touches on a lot of issues that will engage our attention for the rest of the day. So thank you very much. the 12 noon slot, and then we will have general discussions after her presentation before we take our lunch break. And I think that also works fine with my good friend Theo. He indicated that he's very keen to hear what her leadership has to say on the subject. He has to take leave of us, but we will find time in our engagements to actually have a session with him at some point. So I would like to invite Chief Justice Kufu to share with us her thoughts on the subject matter before us, which is lands and natural resources, and how we might use this constitution review process to improve on the current regime that we have. Thank you very much.
Thank you very much, everyone, and good afternoon. I'm going to be very brief. I missed out on yesterday's session, but what I walked into this morning is so much aligned to my personal views and also the lines on which the IEA has been expressing itself on various aspects of our management as a country of our natural resources, that I doubt that I'm going to have much much of value to add to it, except to add to some of the suggestions. I particularly felt very happy with the proposal that instead of all the multifarious commissions, this commission, that commission, that commission, everybody is proceeding in a silo manner, and sometimes in competition and sometimes in contradiction, and so on and so forth. Having one body, whatever it will be called, preferably commission, filled with properly qualified representatives of institutions, and very few private individuals who are there for because of who they know. We need to start avoiding those sort of representations on bodies like that. Would augur very well with us for the country. Because it just boggles the mind. You don't know, the equation just doesn't equate that a country which has been mining valuable minerals and resources for centuries can be classified by any stretch of the imagination as a poor country. There's something that went wrong. That's why you cannot square off that equation. And clearly, it has to do. And today, one of the first things I heard when I walked in was Dr. Mantiao talking about the fact that it seems that we, as a nation, we know we have gold, but we've never really valued it. We know we've got bauxite. We will stream off a whole list of minerals and natural resources that we have, but we have not valued it. It has not been precious to us, and we see it only as the immediate monetary return. And that's why we can even sell national interest in gold mining companies to pay salaries, forgetting that the minerals under the ground are worth more than any salary we're going to pay. So it's important that now that we're taking the opportunity to look at our constitution, maybe what we need is to prescribe. Let's have there's nothing wrong with a prescriptive constitution if the people need a prescriptive constitution. Our constitution as it is now was designed more with protecting the freedoms and the rights of the people, but was very short on assurance of development, economic development, social development. A lot of big statements are made, but very broadly, hardly fleshed out. But because of that, we have not also really in running or in executing or activating the Constitution, we have not really been development focused or development oriented. So we might as well legislate development into the Constitution, because obviously at this point in time we need it, and we need to leave very little to whims and caprices of individuals, whether we elected them or we didn't elect them. There's nothing wrong. Yes, in constitutionalism, one values thin constitutions. But when a thin constitution has not worked for you, it has worked for us in terms of national organization and all that. But it hasn't worked for us in assurance of national development, sustainable national development. So if we need to legislate into that and end up with a thicker constitution, there's nothing shameful about that. We can choose to do that, just to assure ourselves that this time around we're not going to dissipate our natural resources. So that's one as that's really where I'm coming from, and therefore all the relevant provisions that relate to our natural resources. Let's say if we have to double the length, let's do so. But let's make sure that we're coming up with a formula that will be more useful and more helpful. And certainly, like I said, the idea of one commission, independent, and its membership more based on ex officio membership rather than a special relationship membership is something we really need to seriously think about in this exercise. So there's a brainstorming session that we had at the IEA some months back, and we talked about all the natural resources, forestry, etc., and even what should be the definition of minerals and so on and so forth. I mean, let's take, for example, salt. Is it a mineral? Sea salt, is it a mineral? Is it a mineral in the same sense as rock salt in Daboya is? That is something we need to define for ourselves. One is the result of an industry, the other one is stuck in the ground. So we need to be looking at that when the government decides to give salt winning rights to a particular individual company, what are they really doing? Are they restricting activity? Are they doing a land grant? Because salt, I happen to know quite a lot about sea salt, the process of producing it, because my sister was married to somebody who was in that business many years ago. But you know, you collect the water and God does the rest for you, or you by industry, you use heat to speed up the process. But you might as well say that the government owns the sea. Yes, the sea belongs to Ghana, but the sea water, everybody has access to it. And if you're going to channel it and take some to produce salt, that's a different activity. That's industry. But that's just an example of the importance of becoming a bit more definitive and specific about some of the things that we want to do with our resources. And I think it's clear to everybody, and I think we, from what I gathered, you know, Article 257 is going to have to be very carefully looked at, and all the provisions on natural resources. And clearly also, I think there should be a prohibition of the exploitative format of utilization of our natural resources. Exploitative in the sense of colonial formulations of we tell you where it is, you dig it up, I tell you how much it's worth, and I take it all away. And when you need anything from it, like for example, mention was made of manganese. Then when you need manganese, you're going to buy the manganese input from the person you sold your manganese to. And for that matter, we can also look at lithium. Lithium is only one part of what of mineral that is dug up from the ground. And in the end, if it's only the lithium that you want to value, which shouldn't be so anyway, if it's only the lithium that somebody has put a value on, why should you be once again, as though we're back in the 20s, sending away rocks and knowing fully well that at the end of that value chain, there's going to be the batteries, there's going to be the products, the silica, etc., which you're going to buy. At a time when lithium batteries are going to become like gold across the world, we cannot just continue doing that. And that form of concession royalty sort of arrangement between a mining company, a foreign mining company, and the government of Ghana, that should not continue anymore. That should definitely not continue anymore, because the loss to the state is greater than if we had just left the mineral in the ground till we get the full value chain operation available in the country. You can't say that, if we don't, others will. Yeah, well, you have your lithium and you can decide that for the time being we are keeping it, or you have this mineral or that mineral, and for the time being, you're keeping it till you develop your capacity, you improve your capacity, or you own it, you want to bring it out, you want to use it. Yes, buy the skill if you don't have the skill. And if you've valued the mineral properly, the price is under the ground there. So we just need a bit of we need to become a bit more imaginative. And within Africa and outside Africa, there are so many models, and it's almost like every week a new model comes up. But at the very least, we need to make sure that our sovereignty over that mineral or the oil or that valuable thing, the forests, the land, our sovereignty over it remains evident and very tangible and of meaning, because I don't know, other than feeling that you're driven to Galamsey, I don't know what any young person in any of the gold mining areas up to now, what value they think what is under there is to them personally. That's why they're polluting the water. That's why they are polluting the land and destroying the land for generations, simply because all they see is satisfying today's need. Because if you look at a town like Obuasi, or to any of the famous mining towns which used to be part of our geography lessons in the 1950s and 60s, and all those places, they are dumps. Pardon the expression if somebody comes from any of those towns. They are very disappointing, because you don't see what happened to all the valuables, all the diamonds, all the gold, all the bauxite that was dug up. You don't see what happened, what good it did to the town. If anything, you see what damage it did. The birth defects. I grew up for a couple of years in Chebi, and that was when that was in 1956. It was pre-independence, and that was when I first came across cleft lip and things like that. And I realized on hindsight that after we left there, I didn't come across any of my schoolmates having that in the other towns we moved to, because that was the other towns we moved to were not in mining areas. So in terms of quantifying the value of what we have and the price of digging it up and the price of selling it and so on and so forth, we have so shortchanged ourselves. And if the only way we can protect ourselves is with detailed prescriptions in the Constitution, I think we should be able to do that, and it will be justified. And we should also position ourselves in a way where the exploration and the development and the extraction, whatever, and the processing of every valuable natural resource we have will optimally benefit Ghanaians, not foreigners. Ghanaians should be the net beneficiaries. And that starts off with even having some ballpark idea of what we have under the ground or on the ground or in the sea, or wherever we will be looking to extract value. And particularly, whatever we do, the locality of the activity must reflect the value of the work that is going on around them, both in terms not of some token school building and things like, in terms of their health, in terms of their social well-being, in terms of the development of the next generation who will come and take over that operation. That should always be our intention, that eventually, within the foreseeable future, even if you're giving that part of that process to a foreign company, eventually local people are going to become the primary owners, because they are the primary owners anyway. And so so that everything it's not a trickle down, but it's something that comes across the whole board and everybody benefits. And the only other thing I wish to add is that with regard to oil, and that's, I agree that whatever formula we come up with, that formula should cut across all the systems, all the sectors. So, for example, I particularly admire the Norwegian model, whereby they discovered, they exploited, and decided they are exploiting it themselves for themselves. They will pay you. And then the Saudi method. But the method whereby it is not just the raw stuff you're sending out, but you do some value addition, which will create jobs. Because we know that there's no natural resource which is just some unitary element. There's always other things that are attached to it. When I was researching on lithium, I found that it's what you're actually mining is spodumene, and it's got so many semi-precious minerals that come with it. The stuff that's used for mica comes from there. The stuff you use to glaze pottery comes from there. And that's when I realized, so that's why the salt pond ceramics was located where it was, because somebody knew that one day we ought to produce the silica from the hills that were surrounding the factory. So we've had missed opportunities, but there's more where that gold came from. There's more where that silver, bauxite, manganese, you name it, where that it came from. And let's now make sure through the Constitution that we deal with it, and no one will ever have the power to get up one day and say, we've signed this agreement and we signed that agreement and signed that away. And in all this, let's always remember to make sure in the Constitution that the locality, local interest, local authority is also taken into account in all the processes. So, like I said, I only wanted to talk in general because it seemed to me that a lot of very interesting and cogent submissions had already been made with which we are in perfect agreement. Thank you very much.
Thank you very much, Her Ladyship. It appears that this idea of a natural resource super commission, or an integrated natural resource commission, is one that continues to resonate with a number of the presenters. Let me follow up on that particular idea. So, of course, the various natural resource commissions do very different things. The resources are different in kind, and I suspect that the industries that relate to them are also quite different. Do you envision this as a regulatory commission or as a policy planning type commission, right? So you could have something that does, this is like NDPC of natural resources, right? But with a much stronger kind of role within the sector. So one way we could envision it is the president or whoever is the trustee. This becomes the super commission that advises it, develops a plan for the natural resource integrated sector, and advises whether it's Parliament or the president or whoever in the development of policy. Or are you looking at it as a super regulator of the sector, and then in that case, what becomes of, say, the Petroleum Commission, the Minerals Commission? So while I think the principle seems to be resonating in terms of having a body that coordinates our national vision on natural resources across the board, it's not particularly clear what its role specifically is going to be vis-a-vis these other bodies we have currently. Would be my question. Any other?
Thank you very much, Your Ladyship. I have just one question to ask. You spoke about local interests and provision being made for the local community. And I'm wondering, in your estimation, if you want some revenue actually hived off for the local community, revenue generated from these natural resources.
Any questions from the audience?
Yes. One of the issues that worries me a lot is what our scientific community is doing when it comes to exploitation of minerals. We don't have the means to exploit the minerals. It appears the minerals are deep down there, either under the earth or in the sea. Maybe Norway and the rest have what it takes to do their exploitation. So we make ourselves so vulnerable that the people come and tell you, this is what we can do for you. We have found gold here. We can dig the gold for you. And what we want is raw exploitation. The oils and all the byproducts that you talk about is so demeaning that they take everything. It should be raw. You don't refine anything in Ghana. We are almost 70 years. We don't have even one machine which can do any exploitation. Can we start looking at those possibilities? The other one is the money to acquire the machines ourselves. If it's an oil rig, go and find the oil rig. When I was there, I used to talk to the Ghanaian community, and they are always complaining about those of us here, what we are not doing. I said, why don't you put money together to buy oil rig, and you two go and exploit? Let's see whether you can find oil. Say, oh, Your Excellency, how much are we paid for us to go and buy oil rig? So those are the things that actually we should be looking at, because we are too vulnerable. You study the foreign policy of, say, Canada, where I was, and they have what they call foreign policy south of the Sahara. And the only policy is exploitation. No, the other one they talk about capacity building. We'll come and help you to build your capacity. And I asked them to do what? After you have built my capacity, what am I going to use it to do? Then I started casting my mind and eyes about to find out whether I can find even one industry set up here by Canadians. I couldn't find anything. They are all in the mining. They are in the mining sector. I looked at America. I looked at Japan. They don't have anything south of the Sahara. They are just exploiting our minerals and taking everything away. Raw. They don't add value. These are the things we should... Sorry. Good. These are the things we should be looking at. Thank you.
Okay, Chairman.
Oh, sorry.
Mr. Tanko first.
All right, Your Ladyship, thank you very much for the very interesting presentation. Just to maybe to ask, do you see a role for the Council of States, for example, in addressing some of these accountability and other issues we've raised in relation to the trusteeship issue, in relation to the kinds of contracts that we sign, and etc.?
Yeah. Okay. And thank you very much, Chairman. Thank you, my lady. It's just a follow-up for my senior, what he said, and also in terms of the two countries that you mentioned, the Norwegian system and then the Saudi system. I think it's a very good approach for us, but as a country, we always hear that we don't have money. So the government does not... Exactly. So I just wanted to find out what probably support mechanisms or what contribution do you think we can put towards the constitution review in terms of how, when we are negotiating or when we go for the Norwegian style approach or the Saudi approach, how do we go and negotiate in such a way that we can mine, process the mineral, and then pay them to go, so that we still have money to be able to do that? Because we will complain that we don't have, most politicians will say we don't have the money, that's why we get them to bring their machines or get them to mine and then take it off to go and process it themselves. But what can we do as a country? Is it, so I was thinking, could it be that we can take all the, we would say, well, individuals can mine, then the state will have to mine everything underneath the surface. Like, so in terms of Dr. Steve's argument was we have the surface rights and then the minerals right. Can we say that because as a country we want to really put the country first, anything below the surface should be for the government or for the republic, whereby we will take charge, the republic or the country would take charge of that, and then negotiate in a way that would help us to retain the minerals in terms of when they are mined, when they are processed, and we'll be able to add value to it for us to then either export it or process it into any other, or sell it basically, for us to gain that money. Should there be policies like that that should be put in place? Because we cannot continue on the status quo like that, individuals, stool lands, for us to go to that extent. Because I know Saudi is the government that owns a lot of their, so their minerals and all that is their government, is the royal for the country. I don't know about Norwegian, whether they is the country that owns the minerals. So yes, but Ghana, we are scattered in so many things. Families, exactly. Families own lands, stools own lands, government has some of the lands, Tema, some lands are owned by. So it's like the ownership itself is a problem for us. Therefore, what's underneath? So the surface side, we can say yes, individuals, families, stools can have that. but perhaps the ones underneath the surface should be for the state, and therefore the state should be able to make provision for that.
It is Chairman. So you, Noah, and then Kotna.
Yeah, Chairman, thank you very much, and thank you to your leadership for the presentation. So I'm thinking about the proposal concerning a national resource commission or something of that sort. And I'm thinking about other commissions that we have under our constitution and even under other legislative frameworks. And I'm asking myself whether the organization or the constitution of this commission is going to follow similar patterns, where we have the people on those commissions either being politicians or being persons who are being rewarded for their political activities. Because if that is going to be the case, then it's possible that no matter how we are going to arrange our things, it will still come back to that same status quo, where the people who are appointed are either politician-facing people or people who are there because of a reward scheme by politicians. So that is one of the things that I am thinking about. We have a system where the commission is, the arrangement, the constitution of that commission is made up of a few people appointed by politicians, and majority of them are actually industry people who are not really owing any form of allegiance to the politician appointing them. So that it will be technical expertise actually on ground than political compensation to the people who appointed them. Then I was also thinking of the minerals and then a lot of these public lands and our constitutions being owned by the Republic but vested in the President. Now, if for the minerals, for instance, are we going to have a system where, although it is vested in the President, decisions concerning them will be made on the advice, for instance, of the National Resources or Natural Resources Commission that we will have, so that here, that body of technical people are advising the President. The President is acting on that advice, not that the President is basically hearing an advice that he decides what he's going to do, but the President is actually acting on that advice, so that the policy we are developing from this particular commission is one that is not based on, I am thinking that politicians are thinking about the next election. They are very short-sighted in some of the decisions they make concerning national development. So if we leave the minerals vested in the President, and who is just taking an advice that he can decide to act on or reject, then in the long run, we'll still come back to the same status quo. So these are some of the things that I maybe my lady will comment on it. Thank you.
Theo. And then Kwep.
Thank you very much, Chair and her ladyship. Thanks for the comments. I want to just react to a few of the things that have been said. More often than not, we tend to think that what we have is a system we have is not good, and we need to try and develop another one. But I just want to make a few general comments. The natural resources that we have, and permit me to focus on hydrocarbons. We all know is non-renewable. The oil, for example, that Ghana is producing at the moment is about 100 million years old. That's the age of the oil. So when you think about it, the question is that do we actually have the right to exploit resources that are 100 million years old and just in one generation squander it? So this has been a long-standing debate in the field of natural resource governance. The extreme scenario is that then just leave it in the ground. Others will say, no, let's exploit it because this is our time. And I think the balance has been that let's use the resource to launch sustainable development for the future. So first and foremost, there's a need for us to look at the resource in a very different way. The moment we start looking, in the case of hydrocarbon, for example, the moment we start looking at it from the standpoint of tax, royalty, basically revenue, you miss the point, because it has a transformational aspect of it, which nations have leveraged and made them very successful. And so when these resources are found, it is critical that the hold of the resource on behalf of the people undertakes a very comprehensive evaluation, not just of the value, but of the total impact. And her ladyship talked about, what it takes to get it out of the ground. Dr. Mantia was talking about the cost, but there is what we call the tripod, where you look at the resource, you look at the revenue part of it, and also you look at the environmental part of it. So you need to look at it holistically and say, what can we use our petroleum resource for? And there have been questions as to whether we have the money. With all due respect, I don't think that is the issue, whether we have money or not. The way of financing upstream petroleum industry around the world has gone on for many years. And the model we currently have in Ghana, there's nothing wrong with it at all. It's, in fact, one of the best developed models in the industry, thought through with a lot of case studies taken. But it is how we make it work. There was a question about whether we allow the companies to take it raw. In the case of oil, for example, there is a clear provision in all the petroleum agreements called the domestic crude oil requirement that says that once you take the petroleum, the first portion of it must go to meet the national needs before you are allowed to export it. But that must be looked at in a more holistic fashion. It costs a lot of money to produce these resources. A field development could be as much as $7 billion. And typically, a development is tied to some kind of financing. So every cargo of petroleum that you take must go to make some payments. So if you have the domestic crude oil requirement provision and you are required to take a parcel of crude, which is typically a million barrels, you must be ready to make payment for a million barrels. And if you are not ready to make that kind of payment, you would have the opportunity, you can't leverage it. I've heard people say Ghana's refinery cannot refine the crude oil in Ghana. It can refine it, but the point is these financing packages require that every package must go to pay. So if you pick up a parcel and you process, there must be no excuses why you can't deliver, you can't pay for it. You should be able to pay for it. So that's one aspect of it. But I think generally we must have a model, a philosophical model of what we want to use our petroleum resource for. It shouldn't be just on the cases of revenue. This has been done around the world, and her leadership mentioned Norway and other places. That's obviously the gold standard. I mean, they thought through every process of it. And I was just speaking to Prof a moment ago about the United Arab Emirates model. They knew they didn't have enough oil in Dubai, but the model was that we will produce this resource in a very short time, use that money, and then as a form of transformation in the economy and move it to tourism. So aspect of that project was thought through, how they were going to use that to set up the Emirates airline. And once again, I don't think Dubai had the money at that time. The initial aircraft they used for that project were even leased. But they had a model that they're going to use the oil money to develop the city, use the airline as a hub, eventually with no money, now one of the biggest airlines around the world, to bring people to come and see the country. So the point is, it is possible for us to do something similar. Our legislation is good. The industry is very technical. Every aspect of it requires immense knowledge and expertise. There are a number of areas that you lose value, which may be in excess of tax or royalty. I cited an example of the case of a plan of development, which typically could be several $1 billion. An optimization could be something that would be several $1 billion. And I gave you the example that when the ENI project was being developed, the capex for that project was about $7 billion, and I think that was when our GDP must have been around $35 billion. So you are talking about a project which is about 20% of your GDP. This is a big thing. And so an optimization of, say, 10%, 20% of this is a lot of money. Are we prepared? Do we sit and strategize and get everybody aligned of the shared vision of what we want this resource to be able to do for us? So it's a process, and I think the key takeaway is that we must not see them as revenue, but as growth poles, and look at the whole industry around it. And it is possible, and there are many examples around the world that has been done. Within our framework, we could still do that. And maybe, Prof. Prempe, your thought about situating that whole concept in NDPC could be thought about. But the financing, we shouldn't see the financing as a problem. I mean, everywhere around the world, this model works. When the companies come in, it is how we play the industry that gives us value. I believe that under our current regulatory regime, we can achieve whatever we want to do if we are ready to play. Thank you.
Thank you, Her Ladyship. I just can't understand why, as a country, we don't have our own vision of how we want to use our natural resources to develop our country. As he said, financing should not be the obstacle, because we go to Eurobond market, we borrow billions, and you cannot, a few years down the line, pinpoint to what we use the money for. Even roads that we supposedly built with some Eurobonds, 2 years down the line, I mean, there are potholes all over the place, and you can't even call it roads. So if we use that money to develop the oil fields, and we produced the oil ourselves as part of a broader vision of our development. I mean, the question is, do we really have a vision, probably enshrined in our constitution, as to how we want our natural resources to help us develop the country? If the answer is yes, we will be able to find the financing required to be able to achieve that, because other people have done it. And we have borrowed so much to do nothing, when we could have used those debts to develop our natural resources for the benefit of the country. Thank you.
Let me share this experience. In Canada, I asked them, why is it that you are able to derive benefits from your natural resources, and we don't have the deprivation that we have in Obuasi, Akwetia, and other places? And they told me, look, we have a group of people, a kind of either a commission or CSO or something, that once they discover natural resource somewhere, they engage those who are coming to exploit. And then they work on what they call corporate social responsibility and tell them the things they should do for that area. Said, can you share with me? Said, no, top secret. We will never show it to you. So, do we have anything like that? Minerals Commission, Lands Commission? Do we care? That if these laws have worked all this while, why do we have Obuasi and the rest the way they are? If from that kind of, this development process, this regime that we have is something that is working for us, to the extent of where we now having Galamsey, people saying that we want to enjoy now. If we had really talked about it, and what about the investment intention of those people? How do they see south of the Sahara? Are they ready to help us to develop? No. Or they are just coming to enjoy and take possession, exploit our resources? Yeah, they are not blacks. They are not blacks. They have a different color there. And these people see us differently. They are even prepared to work with the Northern African countries. In the different Morocco and the rest, there are things that they are doing, helping them. Once we talk about Africa south of the Sahara, no. Have we thought about those things? So these laws, I don't think they have worked over the years. They haven't. We need to do something about them. Thank you.
Thank you. Okay, so we'll.
Thank you, Chairman. So the idea of Natural Resource Commission has come very strongly. I'd like to pick your mind on how we can tie in environmental regulation as part of an integral process in protecting the environment as one of the core principles, or if you like, vision, vis-a-vis the extraction of our resources.
Okay, so that's a whole lot of questions for her ladyship. I just wanted to make this small footnote. This point, I was in a conversation recently with a Ghanaian diplomat, an ambassador to one of the African countries, while in that country, and he made a very interesting point. He said he had been at a meeting where foreign direct investment and extractive sector and other things had come up, and they were talking about value addition. And he said the very concept of value addition he had a problem with, because implicit in that idea was that what we were bringing to the table had no value, and that the value addition would come from what the others were bringing. You know, so when you think of what we've been talking about, the value, the fact that we don't put a value on the natural resource, and we don't know the current valuation of our natural resource endowment, whether it's gold or lithium or whatever, nobody can put a number to it and say that Ghana's gold is currently, what we have in the ground is estimated to value this much. And he said, you know, we should do something about how we talk about these things, because when you go to a conversation and you are talking about what the other person is bringing as the value addition, you are essentially valuing yours at zero. You are not bringing value. And I thought that was an interesting kind of, you know, mindset change that is probably in terms of thinking philosophically about how we maximize the returns from our endowment. You know, that idea itself, I think, lit a little bulb in my head. I thought it was a very interesting way of looking at the issue. But I just before I hand over to you, I wanted to go back to your local benefits. In the conversations we've had here since yesterday, I think the role for a local community again has come up. I think there is almost an emerging consensus around that principle, that it is fair to make sure that whatever it is that we do with our resource, the locality that is most proximate to the resource would be part of the either one on the front end, part of the process of allocating the resource to a third party that is coming to exploit it, and or two, part of the benefit sharing. And in the first part, on the front end, is this idea of co-trusteeship that Dr. Mantiao mentioned. I would like to get a sense of, I think that is the part that we haven't advanced yet in the conversation. On the benefit sharing side, on the back end, I think there is general sense that, you know, we should definitely make sure that some reasonable benefits goes to the community directly. But on the front end, in terms of bringing local participation or traditional authority participation in giving consent or in the allocation of the resource, I would be interested to hear your views on how we do that, how we can do that. Some of the thinking on that. He's put the co-trusteeship idea on the table. You know, there are just other ideas about prior consent and all of that, and I would like to hear your reaction to that as well.
Thank you. I will not pretend to have...
Okay, so I wasn't seeing what's online, so could you go back to the online? There's somebody online who has a hand. Ben Boachi of Africa Center for Energy Policy. Okay. So I think our leadership will react to the questions and reactions that have come, and then we'll go to the online participant and get Mr. Bembuachi to also make a reaction. Thank you.
Thank you very much. And I was saying that I will not pretend to have an answer to all the questions that have been put to me, because I don't pretend to have the expertise in these things. All I know is that we should be looking at what we can put in our constitution, which will ensure and assure that at the end of the day, our natural resources will, not may, but will inure to our benefit, not of any industries or any groupings or any political parties, but of every person living in Ghana. I think that should be it. And there were the question of local interest, local participation, etc., etc. To the extent that we are able by constitutional provision and enforcement, to the extent that we are able to assure that the Akwetiers and Obuasis and Takwes of this country cease to be what they are now, then we know we have succeeded. We need that. Otherwise we are a failure. And we need to make sure that we will be able to do that. And whether it means that in the process, the process of a location has been identified, or locations have been identified, or a particular mineral has been identified, and therefore discussions begin. What's wrong with the discussions beginning at the local level? They're the ones who are going to be breathing in the fumes. I'm even assuming that we're not talking galamsey. We're talking world-class mining operations. Still, there are side effects. And in my research on lithium, I found out that there are localities in Pennsylvania where there's a lot of spodumene, where the municipalities and the counties have decided it should remain in the ground. They're not interested in exploiting it. They'd rather, I think even the locality where that company, which is the main recipient of the main purported recipient under the lithium agreement, that locality, they don't mine it there. The process, they don't mine it there. So let's, these are things, and let's also give the localities the right to say we're not interested. The fact that we've voted somebody into power, invested the ownership, it's only a legal fiction. It's a trustee, and the trustee is required at all material times to do well, to proceed with the utmost good faith in the best interest of the beneficiary. And if the beneficiary is going to be wiped out in a couple of generations, or they're going to end up with half-wits, pardon my expression, in the locality, that is it. So local interest is is not only the monies that would be flowing in, but the voice in the space. That is also important. That is also important, and that is part of a well-functioning democracy, to be able to design systems whereby the voice of the people does not end on election day, so that in between election days they are just voiceless. No, it's an ongoing matter. That is why there's even local governance, and the voice of the people is supposed to be heard. So whilst we're speaking of what should be the best structure for optimizing the benefits of our natural resources, let's not forget about local governance, because I would have thought that in this current constitution, one of the strongest parts was the provisions on local government, except that we haven't allowed it to work the way any reading of the provisions makes it quite obvious that it was supposed to work in a different way. So, and then as to how the means for exploitation, well, I think there are more experts on this table as to the best way of bringing things out of the ground and making sure that they are used and purposed for the best interest of the nation than I do. What I know is what I've read, but I do know that yes, there's a need for superb and optimal technical expertise every step of the way, and the utilization of technical expertise is something we do not do much in this country. We do a lot of bureaucracy rather than technocracy, and so you know, somebody told me that if we were to troll around the world and go to Norway, go to Canada, go to the US, go to any place where there is mineral and petroleum industry, you will find well-qualified Ghanaians there. They have the technical expertise. So technically, we have the technical expertise. But I choose to believe that we haven't had a school of mines for decades, and departments and faculties of engineering for decades, institution of surveyors for decades, and yet, up to now, we cannot survey our own land. We cannot, you know, I don't know what they do. The things they are supposed to do, we don't have the people. Between those who were originally trained at GSTS, those who were originally trained at tech, as we used to call it, those who are now also being trained, and now we have this whole university of mines. We don't have people. We don't have people because they've all gone to Canada. They've gone to wherever because we do not use them. We do not use them. And so, well, when you're building a constitution, you're also trying, you're also, underneath all that, you're also crafting a national mindset. When this constitution was being drafted, we were in Revo days, when those who were against the revolution had a lot of trepidation, and those who were for the revolution were militant and fisted half the time. But it managed the provisions that we put in the human rights provisions that we put in, the protective provisions we put in, have transformed us in one way or the other. That's why we're now able to run elections, insult each other, and do everything. But at the end of the day, we continue to exist as a nation because we have been transformed by what we successfully put in our constitution. So we should not be afraid of change. Change happens, and if you don't allow change to happen, well, change will happen anyway, but you have no say in what will change you. So the role of Council of State. Council of State is advisory. Now, Council, I suppose that's a different topic altogether for the committee. That one, I think the whole council will be here, not me. They are waiting for their invitation. So, Council of State, in its present, just taking it in its present role, its role is not just to read what the presidency sends to them and advise on it. They can also to raise issues, pressing issues, and investigate and come up with recommendations, which since the Supreme Court decided that advice does not have to be taken, but at least they can advise. And every advice has a moral weight. And indeed, the process of preparing that advice is in itself quite advisory. You learn a lot from preparing an advisory. So the Council of States does have a role, even now, to play in the matter. But that role is between, in fact, the Council of State can also advise all the existing institutions that have a role to play in our natural resources, yes, in the management of our natural resources. And I think what the academic lady, what she said about what's underneath the land. Well, what's underneath the land, so long as it's in the form of a mineral, belongs to the state, to the republic, yes. And so to that extent, that concept is pretty much in line with the UN, the General Assembly Resolution 1803 about sovereignty over your natural resources. So there's that. But I think that in whatever we will be coming up with in a revision of the provisions on natural resources, we should make sure that it tracks the philosophy and the terms of that resolution, and also that not only does it track, it improves on it, because all that it does is set the minimum standards, but minimum standards can always be improved upon. And what else? I think these are the notes I took on the questions, on the comment. But there was a lot of comments that were made rather than questions. So those that were questions, I think, I have not necessarily answered them, but I may have responded to them one way or the other. Thank you.
Thank you very much. You've been quiet today, Professor Jan. But maybe, I think you also yesterday put out this idea of an integrated natural resource commission. Maybe those of you who are here, I don't know if that includes the lands commission, but maybe we would like. I'm interested to hear your reaction to that, being in the industry, having been on the Petroleum Commission and looking at it from that angle. And if Alhaji Sule, if you would like to take maybe take a shot at that question as well. I'm reminded that our online people are still there, so that the hybrid people. So Ben, can you hear us? Is Mr. Ben?
Thanks to all the comments that have come. Listening to the conversation today, I think what I can say is that I hear genuine commitment and concern about Ghana optimizing or not optimizing its resources. To that extent, I appreciate all that I've heard today. But I want to put some things in perspective so that we know what is happening already, and perhaps that helps us to fill whatever gap we may have or may see in the space. But first of all, to highlight that in resource governance, we have the natural resources, and we own it 100% as long as it is not extracted from the ground. We can decide to keep it in situ as it is. But once we decide that we want to extract it, it requires technology, it requires money. To that extent, the technology and money that is required to extract the resources becomes equally important as the ownership of the resource. Because without the two, you're not going to have the resource come out of the ground. And we have to carefully note that. Either the state decides to fund it by itself or raise the money from the private sector. That requirement makes it equally important as the ownership of the resource. And as Mr. Tio Ashrain indicated, it costs in some instances billions of dollars to extract the resources. And for anybody to decide to either not sell tomatoes or any other thing, but put the money into the extraction of the resources, the return on that investment must justify why anybody should put the money in there. One thing that we also often ignore is the risk of even taking that venture in the resource sector, which has to be compensated for as well. And I've heard commentary that we may need to go and borrow on our own to even add value or exploit the resources. But it comes at a significant risk. If you look at Ghana's risk profile in the oil and gas industry, there are companies that have come to Ghana, spent almost $1 billion, and went home without any resources. All right, so that is the scale of the risk that you get into. It's not as if we know that the oil is sitting somewhere and automatically it will be produced. Some investment to discover the oil has to be made, and then when it is discovered, we have a formula on how that resource is actually shared. It applies to the solid mineral sector as well, where companies have to come, explore, discover, produce, and we share. So all those dynamics are extremely important, and we need to carefully understand them and how they play out. Otherwise, we will be pushing ourselves too much. And when we talk about Ghana even borrowing, we have a recent history where GMPC, if you mandate Ghana government to go and borrow, they will quickly want to do that. 2 years ago, I think 3 years ago, GMPC decided to go and borrow $1.65 billion to buy an oil asset, which civil society kicked against and said that it was overpriced, it wasn't worth the amount that GMPC had agreed to actually pay for the asset. When we were able to stop that transaction, A year after, a year and a half or so after, the company sold the asset for $1. But GMPC was not interested. The same company that wanted to pay $1.65 billion was not interested when it was up for sale for $1 because the transaction didn't prove that worth. It didn't prove to be worth that value. So those are the political dynamics around some of the decisions that we can take around, the resource governance. People may want to spend money and not optimize it. I was happy when her ladyship mentioned the Norwegian model. In fact, Ghana is implementing the Norwegian model. The fundamental question is, how have we gotten it so wrong that we are still talking about Norwegian model? We said we should give GMPC a portion of the state interest in the oil so that they can then invest, become the giants that you have in Norway, and be able to produce our oil into the future. They have used the money to do astroturfs, school buildings, and other things non-oil related, and not been able to invest in development of any oil resource. So I'm painting a picture that when we have the governance so poor, whether you establish a new commission or any other institutions to do whatever others have failed to deliver, we are going to go back in circles and nothing will work. So what I'm hoping to see is that this review committee will be able to fix the governance issues which broadly plague Ghana. And once we're able to do that and hold people accountable for the decisions they take, everything will fall in place, including the resource sector. What we have gotten wrong is really the governance, the abuse of power that allow people to take terrible decisions that implicate everybody. And we can't treat them in silos and say, here is the oil sector, here is the gold sector. Let's design some policies to govern it. We have tons of these laws. In fact, even today in the solid mineral sector, we have laws that prevent a foreign company that has put in their money from even mining the ore directly. So it's Ghanaian companies that are actually mining the gold for the foreign companies. Why are we still complaining about not getting our fair share of the resources? So the issue is governance. And if we have a way to tool the governance architecture to hold people accountable, whether you are in oil, agriculture, or wherever you operate, and we can hold people accountable for the decisions that they take for the collective, we would be able to fix all these issues without setting up, multiple commissions and the rest of it. The local content issues, we have discussed it. We have passed many laws. We still have challenges on how we actually implement them. We cannot deal with that in a constitution. We still need good people. We still need people who can be held accountable for implementing good laws effectively. And perhaps the last point, so that I don't stretch it too much, is that when it comes to resource sector, either you get 90%, 80%, or 50%. It is a function of your ability to account for cost of production and the volume of production. I mean, the same oil companies operate everywhere. BP, Shell, Total, they are in Norway, they are in Saudi Arabia, they are everywhere operating. All right. If the country is not able to account for how much it costs to produce a barrel of oil and how much oil has actually been produced, it doesn't matter what your fiscal system looks like, you'll be shortchanged. And that's why it requires that we build capacity. And that, again, cannot be fixed by the Constitution. It has to be fixed by institutions that are responsible. The GRAs, the GMPCs, the petroleum commissions, the mineral commissions, they are supposed to build capacity that enables them to protect the interest of the state. So that at all times we can define what our interest is, and then we take that interest. Other than that, we can put all the laws, we can put all the commissions in place, and we will still not get our fair share as a state. So let me wrap up to say that let's see how we fix the governance issues, hold institutions accountable. You have a minerals commission that is run by politicians. I mean, it's not going to deliver the value that we need to get. You have the Petroleum Commission that does the same. You have GMPC that today has more staff than all the oil producers together. And they are producing nothing, right? They're just taking the money that could go into building schools and developing our country into paying salaries. If we keep doing that, the frustrations will deepen, and it will be as if we are not getting anything from the production of these minerals. But indeed, we're getting billions from these resources, and not much questions are around how the government even uses the money that we get from that resources. 2020, we fought against government deciding to give all our mineral royalty revenues to Mineral Income and Investment Fund, essentially for them to go and gamble with it. And we are giving them over $1 billion so far. So they control all the mineral royalties that we are getting from gold. And they're actually gambling with it. And you see the reports that are coming up today, the kind of investment that they put the money into. If the little that we are getting from these extractive resources are abused in this manner, it is not about who extracted it. It's also about what we did with what we got. All right. We had, again, Theo talking about how Dubai and others strategically positioned themselves to invest the resource revenue into other growth poles. We haven't done that. We just take the revenues and we squander them. If Ghana is getting over $2 billion every year, in fact, it's about $3 billion from direct revenue from gold and from oil every year, we can't even show $1 billion worth of asset from that money. Then the problem really is narrowing down how we actually utilize our mineral resources and not necessarily how it is extracted at this point. So there's a lot that is happening in the space, in the local content space, in making sure that a lot of beneficiation stays in Ghana. I mean, refining and all of that can be discussed, but there is no commitment to actually deal with those matters in practice, and that's where I see the problem. Thank you very much.
Thank you, Ben. I think the committee will be expecting that your written memorandum will help us with some answers or guideposts to unraveling this governance conundrum that you have described. So we will take a close look at the recommendations that you have to proffer to the problems that you have noted. So if Theo, or I know you have to leave shortly. No, if Theo or Alhaji Sule or Professor Jan would like to react to some of the general points made, including on the super commission idea, you could do that, and then you can take leave of us after that.
Prof likes to put me on the spot. Well, and Ben, once again, thank you very much for an excellent delivery. I think you raise very, very valid points. And the little bit I want to add to this is that we don't have a perfect system, but if we manage our resources well, if we govern our resources well, we'll be able to do a lot with it. I just have a slide in front of me that talks about the consumption of domestic gas in this country. So post 2007, when the Jubilee discovery was made, in 2010, production came on stream. There was a big debate as to what we use our gas for. After many discussions, there was a decision that Ghana builds its first thermal plant. Okay? Now, today, about 80% of the gas that we use for electricity comes from that thermal plant. And 70% of the cooking oil, the cooking gas in our homes comes from that thermal plant. And about $2 billion of savings have been made from substituting this gas with crude oil. What has the foreign company got to do with this? It is our decision to create value from our resource. So it goes back to what I think most of us have said today. We need to have a broad philosophy about how we use our natural resource as a basis for launching sustainable development and not looking at it just as a source of revenue. Okay? We may like to change a lot of things, but the point is that what do we do with what we have? When we decided as a country to go ahead and build a gas processing plant and to get all these values after that, I don't think the investors prevented us from doing this. So there's a lot within our power. We must plan holistically to create value from our resource. Else, we would always complain. Thank you very much.
I just have two things. I will start by expressing my profound satisfaction with the presentation by her ladyship. What I would add is this whole thing about value. It starts from our educational institutions. I've been teaching at the tertiary level for years, almost 3 decades, in these resource areas. Mr. Chairman, when you talked about our value as 0 rated, it's coming from the teaching. Anytime you go into a negotiation in any resource conversation, the people who are bringing the money tell you that what you have in the ground has no value. They say it straight in your face, that it has no value. And the reason is, unless they put their capital to bring it up, it's valueless. What they are not telling us is that even buried underground, with appropriate thinking, you can still get value without bringing it out. But historically, we have been teaching our students to think that unless capital and technology brings out the resource, it has no value. And so we need to do a reorientation relating to what we have and the value. The second point I will make, you can see the conversation building around expertise, the right people, either we have trained them and they are not here, or we train them and we don't use them. So in this constitutional enterprise, we should look again at the power of politicians to appoint and remove people. This country's bane is the power of appointment and removal. Unless we do something dramatic about it, this country would remain what it is now and forever, the same way. Now, those of us who come from academia, we are at unease to go. I mean, when I see academics running away, chasing political jobs, I ask them, do you know what you are going to take? A student of yours last year will remove you from the position. Your student will fire you. You know, that's the reason some of us are very quiet, sitting on the campuses. We laugh. You know, my students, they are here. I mean, you know. So, the power of one person to take out the most brilliant and effective person in a position without assigning reasons. We all talked about Article 191. You see how ineffective 191 has been. 191 has not been able to protect a single public officer in this republic. So all this talk all this talk is because in most of our national institutions, we don't have the right people. Where we have the right people, they are scared to death in making decisions. And some of us, I had the privilege of working for almost 10 years as the legal advisor at the Ministry of Lands and Natural Resources. Because I was not within the civil service structure, I could give an opinion to a minister that, minister, if you do this, you would go before a judge one day. But Sule and Co, who were there at the same time, they couldn't do that. No. They couldn't. They couldn't. I had my university teaching job. So I could walk into a minister's office with a document as a minister. You want to sign this? And come down to G1. That was my office. It was called G1. But the other people could not, because they were scared to death. They would lose their jobs. So what I am proposing is even the concept of trusteeship of the president, we should take it out. There should be no vesting of any mineral or other resource in the president on our behalf. If you can create that omnibus natural resource, whatever you call it, and you populate it with the right people, institutional representations, not like the Council of State that has institutional representation and 8 people appointed by the president to go and neutralize everybody. 11 people appointed by the president neutralizes everything. So I told you yesterday, this opportunity may come back again, not in our lifetime. And those of us who are privileged, that is why I came back today. I left everything to come here to show the committee that we are interested in the work you are doing. If you continue business as usual, leave things in the hands of politicians, you will not go anywhere. In all the last 10 political, the last 4 or 5 political campaigns I have witnessed, everybody tells us that they will change the economic paradigm from the Gosisberg approach. From the Gosisberg approach. Have we changed it from the Gosisberg approach? It means that the politicians can't do it. The politicians can't do it. Put these resources under the control of an independent, properly tutored group of people. And you will see the difference, because your Minerals Commission, your Lands Commission, your Forestry Commission, in the last couple of days, everybody who was there has been sacked. People started leaving after the announcement. Not so. And the criteria for appointing people to these positions has nothing to do with competence. You cannot continue to leave the resources of this country in the hands of the uninitiated just because people have won elections. And positions in this country are treated like spoils of war. Spoils of war. And all the political parties do the same. That is why in the conversations you hear what they call politics of equalization. You did it last time, so we are doing it this time. Keep quiet. We should avoid any ding-dong with our resources. That's all we have. And that's all I will say.
Thank you. I think it's, on that. Oh, good. Sule, please have your say.
Well,
and then that will take us to lunch. Actually.
We were picked up from the airport in a minivan. We were picked up from the airport in a minivan. Then the gentleman set the Google directional app. So he started, turn left, turn right. I was the only lawyer among surveyors on the bus. And I was asking the surveyors, did you come to school with these guys who have done this? You know, so why are we not doing same in Ghana? You know, so the surveyors don't like me. They don't like me.
Well, the reason why we don't like you is just the same issues that have been articulated here, the issues of governance. And I think that when we want to discuss this, especially those of us who have virtually served all our time in the public service, you have so much of inhibitions when it comes to discussing these issues of governance. A few examples could suffice. When I served as the Executive Secretary of the Lands Commission, we realized that since 1974, this country hasn't seen any new mapping. The total cost of mapping is normally borne by government, and nothing had been provided through successive budgets for us to have new maps made. Therefore, when Forestry Commission needs maps, they commission a flying, usually by an Israeli company or a British company. When Ghana, Gapoha wants maps on the coastline, they commission that, and you find either an Israeli company, a British company, or a Chinese company. Forestry Commission will do the same. Roads and highways will do the same. And they keep on multiplying these maps. Yet, the Surveying and Mapping Authority is vested in the Lands Commission. So we come up with a very brilliant idea that, look, why don't we have an integrated map of the entire country with even LiDAR, provisions for LiDAR, so that the depths of the soil and the rest can all be determined. And we came up with a very ambitious plan, which cost us $138 million to do it and actually reform the land governance architecture in the country. We didn't have the money, so we thought that let's go speak to Bank of Ghana and see what advice they could give. And they thought that if we resolve this issue around this natural resource management and really have a good land administration system going, the banking sector was just going to shoot off because of the certainty in banking transactions, certainty in locating mortgages and all that. So Bank of Ghana was going to serve to help us get some state commercial banks to support us. All well and good, we went to the Minister of Finance, which thought that it was a very great idea, and we were going to do that. Then suddenly, we were asked to come to the house. And, well, we went.
You don't want to say.
Well, it's still there. Wow. You know, I was told, I was given a cheap proverb. And the cheap proverb is that kwasia ne emuna. And that kwasia ne emuna. Kwasia ne emuna. So if you show your face and say, you get angry and say things that they will go and dig your school background and see that maybe you stole toffee when you were in class 2. And your whole reputation goes. So sometimes you still keep quiet. But The long and short of it is that we were asked to give the contract to a particular entity which had nothing to do with land administration, surveying, or mapping. So that ended it, and up till now, this has not been done. And that also tells you about the efficiency of that state agency. I was born and bred in, I'm talking of the Lands Commission. I was born and bred in a mining town, Prestia. And the town has deteriorated over the years. And some of us just thought that we had to give back to the society to try to see whether we could get investment that could revamp the mining, especially the underground mining in the town. So we put up money together, and a team of us, about 6 of us, traveled to Vancouver in Canada to try to see whether we could get some sort of investment to come and take over the underground mining, because all the big companies were only interested in surface mining. Well, their response was quite simple. They are not interested in the mine. What they are interested in is that to come and buy shares and then get a mining company to mine the gold, the resource, increase their share price, and then they will sell it off. So really, there is no interest of that particular company and the welfare of the citizenry and the rest. All that they are coming, they are looking at it as a business. They just come buy it at the cheapest price they can get, then raise their share value and then sell it off. And that is the model that you see operating, because you give a lot of tax incentives and all that. And then when these come and then they get their profits, they just walk away. But in the local parlance also, the governance issues are there. When you do galamsey in Prestia, whatever you scoop is put in a jute bag called a load. No, the fertilizer bag. So that one is called a load. So the investor, who may be a rich person in Kumasi, Takrady, or in Accra, hires these young boys to go and do the galamsey. And the load is shared as follows. You, the investor, you take 5 loads, that's 5 sacks, for every 10 that you produce. The MP's office in the area gets 1 load, the MCE gets 1 load, the chief gets 1 load, the police commander gets 1 load, then the union also gets 1 load.
I'm happy you didn't say that the magistrate.
That is the mine workers union, the small scale miners union.
Oh, okay.
Also, like, is he going to talk about the local magistrate?
Oh no, I mean this is the sharing, and each of them has a washing bay called a ghetto, and nobody dares go there. Now, what is interesting is that nobody arrests anybody for galamsey in Prestia, because that is the mainstay. And every police recruit who comes to Prestia within 6 months to a year drives a 4-wheel drive. So it just tells you the issue. So when you are thinking about the constitutional arrangements to assure us that we are actually adequately utilizing these natural resources, these are the practical issues that will confront us. We, as Ghana Institutional Surveyors, have already made a submission to the district, so I don't need to belabor it. But what is important for us to look at is the functions of the Lands Commission. At the time this constitution, the 1992 constitution was promulgated, the Lands Commission consists of what is currently known as the Public and Vested Land Management Division. It was subsequent to that in 2008, as part of the land administration process, of which he bullied us a lot about, we got the Act 767 passed, that is the Lands Commission Act, in which amalgamated the surveying function, the land surveying function, the land valuation function, and the land title registration function to join with the public land management function to form the Lands Commission, leaving the Office of Administrators to lands out. But all these land administration units are very inefficient in the sense that resources to work with and the rest is very, very weak. And therefore, it is something that we will have to look at and how to harmonize all these land administration issues. More important for us also is to define, when we are talking about public land, what are we talking about? At the moment, when we are talking about public land, we are looking at it in terms of only the surface lands which government has either acquired directly or vested. But it is important for us to know that our natural rivers are there, our natural streams, the forest, that is in terms of the some of the gazetted acquired, or rather forest reserves, are they state assets? So we will have to find a formulation of land, since the lawyers have a definition of land, what is above it, what is on it, and what is below it. And therefore that covers almost all the natural resources. So if we are defining it, we'll have to look at the coverage in such a way that it takes care of all this. And I think that this question of one overarching natural resource commission is an idea that appeals to us also. And I think further discussions should give us a direction on where to go. Thank you very much.
Thank you very much. If there is no reaction to it immediately, I think it's very clear, succinct. Barring any reactions to that, I think we can break for lunch, and then reassemble for the afternoon part of the conversation. So you are invited to stay, join us for lunch. Thank you.